Welcome everyone to my newest micro course. Today we will study the complexities of rent control in Los Angeles County and Los Angeles City. This is a crucial topic for all landlords operating in this region. We'll cover everything from calculating rent increases to navigating evictions. If you like this training, you can download a free copy of this presentation at nas.io/REAS seminars or follow the link in the comments. Let's get started. First, let's clarify that different areas in the United States fall under distinct regulations. In California, some properties are covered by the State of California rent control. Others in the County of Los Angeles are covered by Los Angeles County's Tenant Protection Act of 2019. And properties in the City of Los Angeles specifically are governed by the City of Los Angeles Rent Stabilization Ordinance of 2021. I will provide a separate micro course focused on the State of California rent control. But for today's training, we will focus on the County of Los Angeles and City of Los Angeles specifically. Within Los Angeles County, rules also vary depending on whether a property is in an unincorporated area, an incorporated city, or under shared jurisdiction. For this training, we will cover both incorporated and unincorporated areas. Understanding which regulations apply to your specific property is the first and most important step. If you need to know, ask your realtor or loan officer. Let's talk about rent increases. Starting January 1st, 2025, rent-stabilized properties use a formula where the annual rent increase is based on 60% of the consumer price index change over the previous 12 months, ending in September. There is not minimum increase amount, but there are maximum increases. In the City of Los Angeles, the maximum increase is limited to 3%, even if CPI calculations suggest a higher percentage. As far as Los Angeles County, the rules are governed by the Tenant Protection Act of 2019 for many properties. This generally allows for annual rent increases of about 5% plus the local inflation rate, with a hard cap of up to 10% during periods of significant inflation. However, some county properties may have exemptions or subject-specific regulations that modify these limits. It's important to verify which specific rules apply to a given property's location to ensure compliance with the appropriate jurisdiction. It's important to understand the differences between city and county regulations. For example, the City of Los Angeles' maximum annual rent increase is 3%, while the county can run from 5% to 10%. The county offers additional allowances for small landlords and luxury units the city does not. Also, the City of Los Angeles requires landlords to provide a much higher relocation assistance than the county for no-fault evictions under the Rent Stabilization and Just Cause Ordinance. The amount varies based on factors like tenant eligibility, income level, and length of tenancy. Generally, tenants fall into two categories. Eligible tenants receive standard relocation assistance, and qualified tenants like seniors 62 and older, disabled individuals, or households with minor children receive higher assistance. The exact relocation amounts varies, but can range from $9,900 to $25,700 per household. You can find the latest relocation assistance figures on the LA County Housing website. There are some special categories that allow for higher rent increases. Small property landlords, those owning 10 or fewer units, may qualify for an additional 1%, bringing the total possible increase to 4%. Luxury unit owners might be able to add an extra 2% for a maximum of 5%. To take advantage of these higher increases, you'll need to submit certification forms to the Department of Consumer and Business Affairs. Implementing rent increases correctly is just as important as calculating them accurately. You must provide written notice to your tenants before any increase takes effect. For increases of 10% or less, a 30-day notice is required. For larger increases, which we will cover in the next slide, you'll need to provide a 90-day notice. And most importantly, document everything. Keep records of all notices, calculations, and communication with tenants for at least 3 years. If you believe the standard rent increase does not provide a fair return and need to raise the rent beyond the allowed maximum due to maintenance costs, repairs, or increased operating expenses, such as adding private security, major property renovations beyond routine upkeep, or other necessary expenditures, you can pursue the fair return process. This requires identifying qualifying expenses, thoroughly documenting all costs, applying through the Department of Consumer and Business Affairs, and awaiting their determination. Small landlords have some special considerations under LA County's Rent Control Ordinance. To qualify for the additional 1% rent increase allowance, you'll need to formally certify your status with the county. This involves submitting property ownership records showing you control 10 or fewer rental units. Remember, you'll need to recertify your small landlord status annually to maintain eligibility. If you believe your property qualifies as a luxury unit, you can potentially add an extra 2% to the allowable rent increase. However, you'll need to document that your property meets specific criteria. This includes documenting high-end amenities, premium finishes, and exclusive building features. You'll also need to provide a comparative analysis showing how your property's rental rates and features compare to similar luxury properties. Let's move on to just cause eviction. Just cause eviction laws ensure that tenants cannot be removed arbitrarily and require landlords to provide a legally valid reason for eviction. These reasons generally fall into two categories: at-fault evictions, where the tenant has violated lease terms, such as failing to pay rent, causing property damage, or engaging in illegal activities. Regardless of the reason, landlords must follow proper legal procedures, including providing written notice and, in some cases, relocation assistance. Failure to comply with these regulations can lead to wrongful eviction claims, which may result in legal penalties. Since eviction laws vary by location, consulting an attorney or local housing authority is essential to ensure compliance and protect tenant rights. There are also no-fault scenarios where eviction may be justified. These include situations where the owner or a family member intends to move into the unit, where substantial renovations are necessary and cannot be completed with the tenant in residence, or where you plan to permanently remove the unit from the rental market. Keep in mind that these no-fault evictions typically require relocation assistance payments to tenants. Understanding the eviction notice timeline is critical. It starts with either a cause notice for lease violations or a no-fault notice for the scenarios we just discussed. If the tenant doesn't comply with the notice terms, you can proceed with a legal filing. This leads to a court process, and if the court rules in your favor, the sheriff can ultimately carry out a lockout. Relocation assistance is a key component of no-fault evictions, requiring landlords to provide financial support to help tenants cover moving costs. For the County of Los Angeles, this typically involves paying at least 1 month's rent directly to the tenant upon serving the eviction notice. However, in the City of Los Angeles, relocation assistance can be significantly higher. This will be discussed next. To ensure compliance, landlords should obtain a signed confirmation of payment receipt and retain records for at least 3 years. Failure to provide the required assistance may invalidate the eviction notice. Maintaining your rental property is not just good business sense, it's also a legal requirement. You must maintain habitable conditions, address maintenance requests promptly, and keep detailed records of all maintenance activities. Proactive maintenance keeps tenants happy, preserves property value, and helps avoid costly emergency repairs down the line. Tenant disputes are an inevitable part of being a landlord. The best approach is to address concerns directly, responding promptly and documenting all communication. If direct resolution fails, consider seeking mediation through LA County's services. For complex disputes or potential litigation, it's always wise to obtain legal consultation from an attorney specializing in California landlord-tenant law. Key record keeping is essential for staying compliant and protecting yourself. Maintain signed copies of lease agreements for at least 4 years after termination. Keep copies of rent increase notices with proof of delivery for at least 3 years. Document all repair requests, inspections, and completed maintenance with dates and descriptions. And save all significant tenant communications, especially those regarding lease terms or property conditions. Staying updated on regulatory changes is an ongoing process. Regularly check the LA County Department of Consumer and Business Affairs website and subscribe to their landlord notification service. Join local landlord associations like the Apartment Association of Greater Los Angeles for timely updates and resources. And schedule annual reviews with a landlord-tenant attorney to ensure your practices remain compliant. A landlord success calendar is an essential tool for staying organized and ensuring smooth property management. It should include key dates for annual rent increases, allowing landlords to provide proper notice and adjust rents in compliance with local laws. Quarterly property inspections help identify maintenance issues early, preventing costly repairs and ensuring tenant satisfaction. Regulatory review dates are crucial for staying informed about changes in rental laws, zoning regulations, and tenant protections. Additionally, landlords should schedule reminders for lease renewals, tax deadlines, and insurance policy reviews to avoid lapses in coverage or compliance. Tenant communication checkpoints, such as periodic check-ins or renewal discussions, foster positive relationships and reduce turnover. By maintaining a structured calendar, landlords can proactively manage responsibilities, minimize risks, and create a more efficient and profitable rental business. Non-compliance with rent control regulations can be costly. Typical fines can start at $5,000, and you could face rent refunds potentially up to 3 times the overcharged rent. Legal expenses can easily reach $25,000 or more. Staying informed and compliant is the best way to avoid these significant financial penalties. You can also consider hiring a professional property manager to keep you on track. Finally, here's a rent control compliance checklist to help you stay on track. Verify the jurisdiction your property falls under, calculate rent increases correctly, provide proper written notice, follow just cause eviction requirements, maintain thorough documentation, and consult with an attorney when needed. Remember, this information is not legal advice and is subject to change, so stay informed and proactive. If you like this training, you can download a copy of this presentation at nas.io/RIA seminars. Or follow the link in the comments. See you in the next training.